Hello everyone, welcome to Conquer Learning and welcome to today's session. I'm Lakshmi Kushwaha. So continuing our Indian Constitution series, today we are going to study the salient features of Indian Constitution. So our Indian Constitution is borrowed, or there are the different sources from where the different features of Indian Constitution are taken up, and there are certain features that are different and separate from all other constitutions available in the world. So in today's session, we would be covering the salient features of the Constitution. Before moving to the salient features, let's understand what are the sources from where the features of this Constitution of India has been borrowed, from where all different characteristics which make the Indian Constitution such lengthy, such unique in nature. So from where they has been borrowed. The Government of India Act 1935. In last video, while covering the historical background in the Crown Rule, we studied about this, the Government of India Act 1935, which played a very major role in giving the base to the Indian Constitution. Maximum of the features, or you can say many things from this particular act, has been added to the Indian Constitution. So what all have been taken up from the Government of India Act? Emergency provisions. So we have three kind of emergencies: national emergencies, presidential rule, and your financial emergencies. And it has been only 3 times when the emergencies have been declared in India. So the emergency provision has been taken up from the Government of India Act, which is covered in part, this is your 18th, article 352 to article 360. Then public service commission, this is taken from it is mentioned in the part 14th, and it article covering article 315 to 323. Judiciary. So we have an independent judiciary. What is judiciary system? So it is an independent, and it is a kind of pyramidical structure where Supreme Court it has high at highest apex level, then we have High Court, and then we have the subordinate or the district courts. So this judiciary has been taken up from Government of India Act 1935, and it is mentioned in the part 5, chapter 4, article 124 to 147. Then the federal scheme. India is in federal government consisting of the characteristics as the federal as well as unitary. Unitary where the central is having complete control, federal where the state is acting or state is having the control. So both state and the central act at their position respectively. Office of governor. So governor, who is a nominal head of the state, this provision or this feature is also taken up from the Government of India Act 1935. So governor is the person who is elected or selected or appointed by the central government. So he is an link between the central government and the state government. This is given under Article 153. This is what we are going to study in coming classes in detail. From USA, we have taken the written constitution. So now there are written and unwritten constitution. Our constitution is written. Now what is this written means here? That it's not easy. You cannot change anything within the constitution easily. Non-written is something where it based on the laws. So written constitution requires an amendments, non-written constitution doesn't. So they are based on the laws. Then fundamental rights, which are taken up from the USA, article covering from 12 to 35. Judicial review. So judicial review, anything the Supreme Court, right? So anything need to be added to the constitution, or anything which changes have to be made into the constitution, the judiciary is having an power to review it. So judicial review, article 13 taken up from the USA. Impeachment of president. So now when the office of the president is to be vacant, or there is some kind of a removal thing that need to be done against the president, it is not a removal process, it is an impeachment process. This impeachment process of president, again we will be doing in the detailed session. Here we are just going to understand the basic features which are taken up from the different sources. This is given in article 61. Removal of Supreme Court and High Court judges, Article 124, Clause 4. Preamble of the Constitution, which is again very important. Independence of judiciary, like judiciary system which we have, being making it as an independent, right? It is not based on constitution, or it cannot be affected by any other thing. It is independent in nature. This is taken from USA. Appointment of vice president, taken from USA. Then DPSP, Directive Principles of State Policies. So our fundamental right, which are the rights provided to the or citizens of country, as well as some of them are provided to the non-citizens as well. So these fundamental rights are justiciable, in the sense they are, if anyone takes away my fundamental right or stops me practicing my fundamental right, I can directly go to the Supreme Court. But so there is an even constitutional remedies for it. But DPSP, directive principles, are the guidelines. They are the guidelines given to the state. So while administering or ruling the state, any of the state within India, what all guidelines they need to follow for the proper administration. Now they are not justiciable, means they are the obligation in themselves but not justiciable in nature. Given in part 6, article 36 to 51. Methods of election of president, article 55. Members of nomination of Rajya Sabha by the president. Members of nomination of Rajya Sabha, so there are the 12 nominations which are made by the president. So this nomination is taken from the Ireland, part 5, article 80. Now moving to British UK constitution, this is writs. These are called as right of constitutional remedies. So any of my fundamental right is violated, in that case writs are issued by Supreme Court and High Court. So these are considered to be constitutional remedies. These are given under Article 32 to 26, which we are again going to study in our detailed class. Parliamentary form of government. Indian government is a parliamentary form of government. There are two types of the government, parliamentary and presidential. In parliamentary form of the government, executives are responsible to the legislature. However, in presidential form of government, the executives are independent. They are not responsible. So they are non-responsible to the legislature. They are not answerable to them. So America has a presidential form of government. We have a parliamentary form of government. The idea of single citizenship, part 11, article 5 to 11. So what is single citizenship? In India, we don't have a citizenship for state. A person belonging to India has only one citizenship, that is Indian citizenship. Parliamentary privileges. So the members of parliament, they enjoy certain privileges. The positions, the places, the positions within the parliament, they enjoy certain privileges. This is also taken from your UK and article 105. Rule of law. So now what is this rule of law? It means that constitution or country would be followed according to rule of law. So this means anything which happens in country, the first thing that would be checked is law, where the law exists or not, if there is any legislation or not, and accordingly the decision would be taken. Then we have nominal head. President is the nominal head of the country. This is again taken up from British. Cabinet system of ministers, post of prime minister, provisions regarding the speaker of Lok Sabha, taken up from your UK. Germany, that is your Webinar constitution. Suspension of fundamental rights during the emergency, article 356. So fundamental rights are not absolute. They can be amended, they can be taken away, suspended. So this suspension of fundamental rights during the emergency is taken up from Germany. Now, while just like in COVID, the fundamental right of forming an association, or the group was taken away because the emergency was there, right? There was an emergency where it was required to maintain the social distance. From South Africa, amendment of constitution. So this is what we are going to study in the basic structure of constitution. how the constitution, how things can be added to the constitution, how things can be removed from the constitution. So this process of adding and removing the things from the constitution is called as an amendment. So there is different methods through which the constitution can be amendment. This process of amendment taken up from South Africa, given in the part 20, article 368, election of members of Rajya Sabha. So now how members of Rajya Sabha would be elected, the process taken up from South Africa. USSR, Constitution of Soviet Union, Russia. Fundamental duties. Now what happened? Fundamental rights are there, DPSP are there. Fundamental rights are rights which are enjoyed by the citizen. DPSP is an obligation of the state government. What about this fundamental duties? Like when I am being given certain rights, it is my duty to respect, like duty to respect national anthem, duty to respect to national flag. This should be made compulsory. So in order to have that fundamental duties, Mrs. Indira Gandhi actually introduced in her tenure through 74th amendment, the fundamental duties was introduced, and it is in the part 4a, article 51a. So there is only one article for fundamental duties. Then the preamble, in the preamble, the ideal of justice need to be social, economic and political. In all three way, the justice has to be socially, the person to be treated socially justice, economically and politically, taken up by USSR. Moving to Canada, federalism with the strong central government. So federalism is existence of both central and the state. Power is being distributed between the state and the central government, but central government is considered to be more powerful. Like during the emergency, the state government automatically dissolve, or not actually dissolve, they are dominated by the central government. Central government controls everything. Advisory judiciary of Supreme Court, Article 143. Center appoints the government to the state, Article 155, 157. So that is here who would be appointing the governor. So center appoints the governor. This particular appointment is taken from Canada. Residuary powers. So we have 7th schedule, we have concurrent list, we have union list, we have state list. Other than this, there are certain matters which are to be called as residuary. So residuary powers are vest with the center, article 248 of constitution, entry 97 of union list. Australia. Concurrent list. What is concurrent list? Kind of the matter where both the central government and the state government can frame the law, like our labor legislation is a matter of concurrent list. Here both the state and central government are given the power to make the legislation. So we have the state laws as well, like Bombay Industrial Relation Act, and central like Mines Act, Maternity Benefit Act. So the labor legislation where both central and state government can act. Freedom of trade and commerce, part 13th, article 301 to 307. Joint sitting of two House of Parliament, article 308. So when Lok Sabha and Rajya Sabha, they are stuck, deadlock is there, they are not able to come up to certain decision related to certain bill, then the joint sitting is being done. This joint sitting is taken up from the Australia. France. Again, the ideals of liberty, equality, fraternity and republic given in the preamble, taken up from the France. Japan. Procedure established by the law, article 21. Now, rule of law and procedure established by law means here everything would be according to the law. Here it would be checking first, do we have the procedure for it or not, right? We will study the difference between them in coming slides. Now that was the sources. We have 11 sources from where the features of Indian Constitution has been created or taken up. Now let's understand one by one the salient features of Indian Constitution, important from the exam point of view. It's the lengthiest written constitution. Indian Constitution is the lengthiest constitution. Reason, it consists of 470 articles, preamble, 25 parts and 12 schedules as per 2019. When it was framed, initially it contained Preamble, 395 articles, 22 parts, and 8 schedule in 1949. So it is a written constitution. America has written constitution. British has unwritten. We follow this. It has been taken up from the America. So we have written constitution and it is the lengthiest one. Lengthiest one. Now why it is lengthiest? Why it is having elephant size? Why such big or the huge constitution is there with such large number of the schedule, large number of article? First thing is geographical factor. India is divided, it is unity in diversity, it is diverse country consisting of different geographical area, different kind of people, different culture. So our constitution actually provide features or provide the provision for each of them. Historical factors, Government of Act 1935, it is taken up from there. Single constitution for center and state, since we follow for both of them, the center and state, we have the same. Dominance of legal luminaries means this constitution was actually prepared by most of the lawyers, those who had legal knowledge. So the language they used, the way they have framed it is making them lengthy, everything. So when the lawyers or the legal luminaries prepare anything, they would have everything summed up in one thing. Now, it contains fundamental principle of governance and detailed administrative provisions. So, how governance would happen within the country and administrative provisions, everything is given in one constitution and hence it is the lengthiest written. Next is, just now we saw the sources. It is borrowed or drawn from the various sources, borrowed from the different countries as well as the Government of India Act 1935. The borrowing of constitutions features from different country. Dr. B.R. Ambedkar acclaimed that it is a ransacking all known constitution of the world. He is known as father of Indian constitution. He studied almost every constitution in the world and then he formed the India's constitution and hence he named or called it as ransacking. Third feature is blend of rigidity and flexibility. Indian constitution has got both the future. Rigid is with America, flexibility is with British. Now what is rigid? Amendment in the constitution, anything which is to be added to the constitution, there are certain feature where there is a rigid. It's not easy to amend it. So it requires a special procedure for its amendment. However, few of the features can be amended in the same manner as the ordinary laws are made. Now, what is this rigid method? What is this flexible method? Let's understand. So, Indian constitution is synthesis of both rigid and your flexible method. It is given in Article 368, which provide that there can be two types of the amendment. So this is talking about the rigid where amendment requires a special majority or special provisions. So first is special majority of parliament. The members of parliament, special majority of parliament, that is two-third majority of members of each house present. So Rajya Sabha, Lok Sabha, if there are 100 here, if there are, I'm just giving you the example, if there are 100 here, so two-third of majority of member each. So two-third here, two-third here, right? They should be present and voting. And majority of total membership of the house. So this is people, those who are present, two-third of those who are present plus, so this two-third plus total number. So we have in Rajya Sabha, we have around current, if I talk about the current number, Rajya Sabha is having around 245 seats and all. So 245, I'm not sure on this, but yes, 245 seats and all. So majority of this 245, there should be two-third as well as the majority of it. Then the amendment can be done through a special majority. However, special majority of another method is special majority of parliament with the ratification by half of the total state. What is this? We'll come and study in the amendment wala chapter. Okay. Some provisions amended by the simple majority of the parliament in a manner of ordinary legislative process. So these two were the ways through special majority how Indian constitution can be amended. However, we have the provision for simple majority as well. So what is simple majority? So if any of the legislature has to be passed or bill has to be passed in the Rajya Sabha and Lok Sabha, it just requires simple majority, maximum more than 50% to be voting, right? So that is the simple majority. Then comes your federal system with unitary bias. We have a federal system. Federal in the sense central with the state government. But at the same time, we have unitary. What is this? Though the power is given to the state or distributed between the state and the central government, at certain point of the time, the central government is having the strong. It is strong and it only makes the decision. So what are the characteristics of federal system or federation? We as in India, we are the federation. So we have two government, yes, central government and state government. Division of powers, yes, there is a proper division of power between central and state government. Written constitution, supremacy of the constitution and rigidity of constitution. Constitution is considered to be supreme of all. Everything is below the constitution. Most supreme is the constitution. Rigidity, it's not easy to amend. Independent judiciary and bicameralism, this is upper house and the lower house, and this independence is Supreme Court, High Court and subordinate court. They are independent. They have the power for judicial review even for the constitutional review. Constitutional amendment. What are the characteristics of unitary and non-federal? Strong center, single constitution, single citizenship, flexibility of constitution, integrated judiciary, appointment of state government by the center, all India services, emergency provision. Let's understand this. Unitary का मतलब होता है one. So when there is an unitary, central government force में आ जाती है, central government becomes more strong. सिंगल कॉन्स्टिट्यूशन का मतलब होना कि सेंटर और स्टेट के लिए दोनों के लिए एक ही कॉन्स्टिट्यूशन है. सिंगल कॉन्स्टिट्यूशन मींस it is single, shows that we are one. Unitary, we have single citizenship, though powers are distributed, the citizenship is only one. Flexibility is there, so flexible enough, it can be amended by simple majority. We have integrated. Now what is integrated? Like though we have judiciary system, High Court, Supreme Court and subordinate, a person first have to approach subordinate court, then High Court, then Supreme Court. So Supreme Court is apex. So this is an integrated system. Appointment of state government, governor. So here, though he is a nominal head of the state, he is appointed by the center and he works as a connection between the center and the state. All India service, emergency provisions. So this all shows that we have a unitary structure as well. Next, moving. Term federation not mentioned anywhere. Article 1, India as an union state. Though we call it as a federal system, in constitution federation is not mentioned anywhere. ये कहा जाता है कि हमारी जो सिस्टम है फेडरल है क्योंकि सेंट्रल गवर्नमेंट और स्टेट गवर्नमेंट दोनों है, लेकिन ये कहीं पे कॉन्स्टिट्यूशन में मेंशन नहीं किया हुआ है. बट आर्टिकल 1 कहता है इंडिया इज द यूनियन ऑफ स्टेट, यानी अलग अलग स्टेट्स को मिला के इंडिया बना हुआ है. So Indian Federation is not the result of agreement of the state. India किसी agreement के तहत नहीं बना है. It is having, they came together and they formed India. Or India has given actually right, or every state in India, they came together to form India. So India is, whenever requires, it can dissolve the state, create the state. So it is as in whole. So no state in India has a right to cede from the federation. अगर अभी state कोई बोलता है कि मेरे को separate, I want to get separated, no, it's not possible. According to KC, it is a quasi-federal. Federal is in the form, but in unitary spirit. So federal, it is the form in the federal, but unitary. Unity is one spirit. Morris, bargaining federation. Granville, cooperative federation. Then we have parliamentary form of government. There can be two two types of the government, we parliamentary and presidential. British parliamentary system of government and not the American. We follow British. Now, when we say parliamentary form of government, it means here executives are responsible to the legislature. They are not independent. However, in presidential, they are independent. They are not responsible to the legislature. So, Westminster, it is also called as Westminster, principle of cooperation and coordination between legislative and executive organ. So everything work integratively here. हर चीज चाहे वो executive department हो, executive level हो, चाहे वो legislative है, they are integrated, responsible होंगे. Whereas in presidential form of government, we have doctrine of separation of powers between the two organs. Means legislative acting separately, executive acting separately. In parliamentary form, we have nominal head and real executive. PM, president is nominal head, real executive is our prime minister. Majority party rule in India, the one who has the majority will be ruling party. Dissolution of Lok Sabha, lower house. So, if there is no majority, the Lok Sabha can be dissolved. Membership of minister in legislation, PM and chief CM, PM or CM, chief minister or prime minister's leadership. Collective responsibility of executive to the legislature. So this is the parliamentary form of government that we follow. Synthesis of parliamentary sovereignty and judicial supremacy. Parliamentary sovereignty means parliament is sovereign and judicial is supreme. Our system of judicial, Supreme Court, High Court, that is supreme. And India is synthesis of this two. What parliamentary sovereignty is of British Parliament, judicial supremacy is your American. What is the synthesis? Indian Constitution is. What does this mean? Supreme Court can declare the parliamentary law as unconstitutional through a judicial review. So whenever Supreme Court feel that this amendment or this law is not in the favor or it is affecting the basic structure of constitution, somewhere causing a damage to the basic structure, it can declare it as an unconstitutional by the judicial review. Similarly, Parliament can amend the major portion of constitution through the constituent power. Parliament has the power to amend the constitution by using its constituent power. Integrated as well as independent judiciary. We have a judiciary system which is integrated and independent. Why independent? Because it is not why it is independent? Because it is not affected by any of the things. And why integrated? Because for both the center and the state, it is the same system. And Supreme Court, High Court, lower court, they all act integrated to each other, right? That's why we have integrated and independent judiciary. Fundamental rights are the basic and very important part of our constitution. Part 3 of constitution guarantees 6 fundamental rights. We are going to do this in very detail in coming classes. So right to equality, Article 14 to 18, right to freedom, Article 9 to 22, Article against exploitation, 23-24, religion, 25-28 article, culture of educational right, 29 and 30, article of constitutional remedies, that is 32, that are writs, right? So we are going to anyway study in the detail, so that's why I'm not going to explain it right now. These fundamental rights promote the idea for political democracy, justiciable in nature. What is political democracy? So we have the justice, which should be social, political and economic. Now what is political democracy? As a citizen of country, as a citizen of India, I have I should have my freedom to express, my freedom to talk, my freedom to roam around. That is the political democracy. Should given us freedom to participate into the election, freedom to be a part of the system as well, to run the country. So this all is the political democracy. Justiciable in nature, that means if my fundamental rights are violated in any way, I can go to the Supreme Court. Aggrieved person can directly go to the Supreme Court. Supreme Court, when it feels that fundamental rights are violated in any reason, issues the writs, right? This writs tries to hold back the fundamental right. The fundamental rights are not absolute, means they are not permanent in nature. They have the reasonable restrictions. It can be suspended during the national emergencies except Article 20 and 21. Then we have directive principles of state policy. Part 4 of the Indian Constitution. Dr. B.R. Ambedkar call it as a novel feature, promote the ideal of social and economic democracy, establish the welfare state. So please remember DPSP was introduced with an objective to make India a welfare state, a state which is taking care of citizens of the country right from their birth till the death. So it tries to fulfill the welfare state terminology which is given in preamble as well. Three categories of DPSP are socialistic, Gandhian, liberal and intellectual. We are going to study them in detail in coming classes. They are non-justiciable. Non-justiciable, you cannot go to the Supreme Court. It means suppose our constitution says it is the obligation of government to make sure that they are working toward the development of the state. Now, during the election, the leaders come to your houses and they say, give us vote, we will be developing your area, we will be making the roads and so on. Now, when they come into the power, if they are not doing so, they are not making the road, you cannot go to the Supreme Court that leader said this and now they are not doing. No, it is not justiciable. But they are moral obligation of the state authorities. There was a main case, renowned case, Minreva Mills case 1980. Supreme Court held that Indian constitution is founded on the bedrock of balance between the fundamental right and DPSP. Please remember this is very very important. So there was a question around came forward, which are more important, fundamental rights or DPSP. So this case actually cleared it. There should be a balance between both of them. They need to go hand in hand. Fundamental duties. Now, these fundamental duties were added by 42nd Constitutional Amendment Act of 1976 during the national emergency declared by Indira Gandhi 75-77. This fundamental duties were actually recommended by Swarna Singh committee looking into the situation which was happening during internal emergency. Indira Gandhi formed a committee called as Swarna Singh committee, and she wanted them to come forward with certain provision which will make an citizens more responsible. So they recommended fundamental duties. So by the 42nd amendment, these fundamental duties were added. By 86th Amendment Act 2000, one more fundamental duties were added into the Part 4A. Only one article is there and there are 11 fundamental duties. Again, they are non-justiciable in nature. Now moving to next, this is the 10th feature, secular state. What do you mean by secular state? Secular state means India is a secular state. What does it mean? It means it does not uphold any particular region as an religion as an official. We don't have any, we Indians or we India as a country are diverse country having different kind of religion. But as a country, we do not uphold any particular one religion as an official religion. So this is called as in secular. This was added to the preamble by 42nd Amendment. Very important to remember. Article 14, 15, 16, 25, 26, 27, 28, 29, 30, they all uphold the characteristic of being secular. We'll do in the details in coming classes. Positive concept of secularism. So it is taken up from Gandhiji's positive concept of secularism, which believes that equal rights should be given to all religion. All religions should be protected equally. Every person have the freedom to practice, propagate any kind of religion they want. So that is a positive form of the secularism. Universal adult franchisee, very very important. In India, elections are made through the direct election through universal adult franchisee. They are the basis for the election of Lok Sabha and state legislative assemblies. What is this? A right to vote is given to a citizen who is not less than 18 years. This was added by this 18 years was reduced from 21 by the 61st Amendment of Constitution 1988. It makes democracy more broad-based, enhances self-respect and prestige of common people. So when I am allowed to select my own leader, it give me a kind of prestige. Oh, I selected this leader. So it create a self-respect. Single citizenship in India, we have only one citizenship. If you are the Indian citizen, you cannot acquire the citizenship of any other country. And if you acquire the citizenship of any other country, automatically you would lose the Indian citizenship. But they all citizens enjoy some political as well as the civil rights. We have some independent bodies who regulate their own working, like your election commission, CAG, Comptroller General of India, ठीक है, Comptroller Auditor General, UPSC and SPSC, Election Commission, this given in Article 324 and 325, they are kept independent for free and fair election of Parliament. कोई भी घपले नहीं होने चाहिए. There should be no malpractices happening. State legislation, Office of President of India and Office of VP. Audit of accounts of central and the state government authorities or the bodies is done by Comptroller Auditor General. Guardian of public purse and comments on legality and property of the government expenditure. तो गवर्नमेंट में क्या एक्सपेंडिचर आ रहा है, राइट, कहाँ क्या खर्चा हो रहा है, CAG does that.